All right, so that'll bring us next to Holderman et al. The Buckman, or Holderman v. Buckman et al. Filed 24-9044CH. And we just did a courtroom renovation and it looks...
Here we go. Case officially on the record. Buckle up, folks, because this isn't just about land. It's about neighborly lines blurred, decades of shared use, and whether friendship can survive courtroom crossfire.
Great, but I do apologize. It doesn't seem to accommodate multiple counsel super well.
Thank you. We did Emmett County. It was unbelievable. That can make 2 out of the 3 courtrooms smaller. It's like, is that the tax dollars at work or what?
Well, part of what we did, frankly, was we made the jury.
Quick side note. The judge just slipped in a classic courtroom truth. ADA compliance matters more than lawyer elbow room. Accessibility always wins over comfort. Still, imagine trying to argue your case while bumping shoulders with co-counsel.
Witness stand ADA compliant, and that took up more space into the well of the court. So something had to give, and it was either the judge's bench or the lawyers or counsel tables. And so I suppose you got the shoulder. All right, so we are on my civil docket. I am providing public access not only in the courtroom but also online. Just want you folks to know that. And we are here today. Looks like defendants Buckman filed a motion for summary disposition. I reviewed the plaintiff's response. Defendants Cooperative and Cisco filed a response in support of that. Plaintiffs filed a motion to strike that initial.
The procedural skirmishes, motions to strike, amended responses, who gets a piggyback on whose arguments. Lawyers love this chess game. But watch closely. The judge is already hinting that all this motion drama might be background noise compared to the big question, summary disposition.
Response for seeking relief for those defendants without a separate motion. It looks like, and there's responses to that, motion to strike, but it looks like defendants Colton and Cisco filed an amended response that maybe fixes that problem. All right, so let's have counsel state your appearances for the record, beginning with plaintiff.
Yes, Your Honor. Joseph Sias on behalf of Mr. and Mrs. Holderman.
Kevin Cleaborn, I represent Mike and Becky Buckman.
Lawrence Hanson on behalf of Mr. Cisco and Mr. and Mrs. Colton.
Okay, and is Richard Reeves present? No, and is Doris Reeves present? Okay. Mr. Reeves is representing himself, filed a letter answer. It wasn't signed by Doris, so there was a default entered on her, but they are both in pro per. Okay, so Mr. Zayas, I guess my first question is, does the amended response address your concerns? And we're not going to hear.
Pause here. The judge is laser focused on the big domino. If the Buckmans win summary disposition, everyone else in line topples too. That efficiency in action, or as some might say, the legal version of one ring to rule them all.
Your argument about striking their initial response?
Only if, Your Honor, that the the defendants aren't going to request summary disposition on their own behalf.
Well, I don't know, because I guess my other, and I don't want to jump the gun here to I want to hear argument from all sides.
Sure.
But if Buckmans are entitled to summary disposition, wouldn't everybody? I mean, these are co-tenants.
Right. I mean, there are some similar issues. I understand that. My real issue.
Similar? How would they be any different? I mean, the court rule says if I conclude that the facts are such that a party's entitled to judgment, then I should enter it without delay. So if Buckmans prevail today, it seems to me all the defendants would prevail today. Why would there be any difference if they're co-tenants?
My real issue with the pleadings that the Buckmans filed, Your Honor, was the fact that they added additional arguments, in fact, even adding additional case 3 days before my response is due. If they simply filed a concurrence saying exactly what the court just said, I think it'd be a completely different situation. But when, you shorten the time I have to reply by 2 weeks by adding additional arguments and even referring to another case, then I think that's a different matter. And that is my real issue with the Cleverance trying to kind of add themselves onto this. It wasn't a simple, yes, we concur, us too. It was, here are these other arguments that why we should grant us summary disposition, which are not exactly the same as what the Buckmans filed.
Oh, okay. All right. Well, and I know there was a response to your motion to strike, and so you all, or many of you, seemed to care a lot about that. I want to assure you, I cared very little about all the details of when it was filed and whatever. I read all this stuff. You all did a great job filing all this stuff. So I am much more interested today in the, you can make whatever arguments you want to make. I am much more interested today in the substance on whether the Buckmans are entitled to summary disposition. And it seems like if they are, that's the first domino and everything falls after that. So that would mean it's your motion, Mr. Cleveland.
Thank you again. Good morning again, Your Honor. It seems like from the plaintiff's view of the world, they pled adverse possession, hostility, et cetera, time and time again. But the facts at their depositions just shout loud that there is absolutely no element of hostility.
And here's where it gets spicy. The defendants argue there was no hostility in the use of this driveway. Translation? The neighbors got along too well for this to count as an adverse possession claim. Who knew being too friendly could backfire in court?
Whatsoever. And any kind of claim like that has to be inconsistent with the rights of the defendant. And so, is there anything anywhere where the use of that drive was inconsistent with the rights of the defendants? And the answer is no. The issue of even the extension of that drive onto the plaintiff's property, Plaintiff Rich Holderman testified, well, I put that in for Mr. Covington's father, Grandpa Covington. He never said, well, I did it because I wanted to, I did it because I need to, or anything like that. The plaintiff, Julia Holderman, testified it was for the defendant's guests. And so even that extension of the drive onto their property from the upper level was not done under a claim of right. And so, you know, every case that's out there having to do with this type of prescriptive use claim has some kind of element of hostility, and there just isn't any. And so when we go back to the records that we attached to our motion, where the Buckmans have records of gravel dating back to 1994, and then the plaintiffs have nothing. I mean, the only thing that they've produced with regard to any kind of documentary evidence at all is the purchase of an Argo and a Kubota side-by-side. And so it just seems to me that there's just nothing. And so when the plaintiffs admit, yep, we're friends and we do it all together, and they really have no comeback even to anticipating their best argument. Gee, we bought in 1984 in land contracting, so we were there before you. But when Mr. LeBron testifies, I put up a lock and cable while I was there for the 6 years, and I never saw the plaintiff using it at all. Again, there's no continuous hostile claim of right, 15 years, etc., that the plaintiff would have to establish to take away a property right of the defendants. And so, again, when I'm glad that counsel for plaintiff attached the deposition transcript of Julia Holderman. So at page 25 of the deposition, she testified when I asked her a question about, how does the whole gate kind of thing. She said, normally we'd ask them, meeting the competence, permission to open the gate. Can you please open the gate? We need to get down. Well, my goodness, there is no hostility at all. If they're best buds with a 1/4 owner of the tenant in common property, then again, there is.
Boom! Smoking gun moment. The plaintiff literally testified. We asked permission to open the gate. That line could kill an adverse possession claim, because asking permission implies you knew it wasn't fully yours to begin with. Permission and hostility are legal opposites.
Nothing that the plaintiff has shown, even an iota of a claim of right type thing to take away a property right.
So can I ask you, in your motion, you spend a lot of, you spend some amount of space documenting the friendship over the years between some of the parties. And at first blush, seems that plaintiff in the response was making a fair point that the hostility element is a legal term and not a term of emotion. So maybe you can help me nuance that. You're not saying that because they were friendly that defeats a claim of hostility, but that therefore it wasn't against their interest or a claim of right because it was a cooperative use? Is that?
Yeah, so I think the case that they cited a couple times, that Munro versus Riddle case, was their primary argument with regard to, well, gosh, the one owner of the property knew that the drive to the neighbor cut across the corner, and they didn't do anything about it. They never discussed it. They basically let it go. But again, that was not a case that they're relying on. That was a shared driveway issue. And that's right.
But you'd acknowledge that hostile use doesn't mean angry use.
No, it doesn't have to be,
use.
it doesn't have to be in your face type thing, but it still, throughout every case out there, has to be.
Notice how the judge presses a lawyer. Hostility isn't about anger. It's about legal inconsistency. You don't need to be enemies, but you do need to act like you own the right without asking. Key nuance that trips up a lot of property disputes.
Inconsistent with the rights of the defendants in this case. And so, when there is, gee, we're having parties all the time, we're best friends, etc. And it just speaks to the volume of evidence that is on the defendant's side with regard to the permissive use. And again, the Munro versus Riddle case was just a corner of the property that was used exclusively or primarily by the neighbor. That's why I thought that case was easily distinguished. The only thing that I could add to what I tried to provide to the court is with regard to our claim for summary disposition on the riparian rights issue. I finally found a bigger, better plat that's clear of Vincent's plat. I do have a copy of it I could share with the court. I had a really poor blow-up copy, but here's the primary issue with regard to our trespass claim. I tried at Mr. Holderman's deposition to get him to appreciate the issue that the riparian survey was measured from the section line 105 feet. And so if you look at lot 15, can you see where there's a little arrow and there's 13.72 feet to the south of the section line? So that's where, again, I can't win a case at deposition. I just need to try to establish facts. And I finally raised the white flag and gave up trying to get him to appreciate that the riparian survey that we have prepared went 105 feet from the section line north to establish the fact that their dock was trespassing in the defendant's lake space. And so it's just a bigger, better, clearer issue with regard to what was the debate at his deposition of did their dock offend into the defendant's lake space or not. And then when counsel went ahead and argued, well, gosh, the dock isn't there anymore. Everybody can see the dock that they've put back in this year. They've since the lawsuit was pending, 24 and 25, they put the dock out, they put the shore stations out, they've got the stuff in the water that they always had. So to argue that, it's not there anymore, it didn't make sense to me. I was really confused.
And your counterclaim, do I understand right, that's based on, well, here we've got this riparian survey and there's really no countervailing facts submitted by the plaintiffs other than saying they just disagree with it.
Correct, that's it. So, it was, riparian surveys, as the court probably knows, are not cheap things. So we went ahead and had one commissioned in 2024. And again, the admission at their deposition was, for the last 3 years, we've gone out from the same point just inside their property line and have angled out into the water. And so it just seems like, it may be not tens of thousands of dollars worth of damages, but obviously when they trespass and put their dock on the bottomlands of my client, and then, more boats on the side of the dock that takes up more lake space, there is an element of damages to that. So I wish we would be all done here today, but I would ask that the court dismiss the plaintiff's complaint, and again, just set a hearing for our counter complaint for the.
And just when you thought it was about dusty driveways, we get riparian rights. Yep, lake docks and water access are now in play. Property law loves to complicate itself. Land, water, friendship. This case has it all.
Riparian space intrusion.
Thank you. So I think in the interest of allowing a joint kind of response, I'd like to first next hear from Mr. Hanson on his concurrence in the relief, and then I can hear from you, Mr. Zayas. Go ahead, Mr. Hanson.
Your Honor, you indicated that you read the response and the amended response that incorporates the additional arguments that I thought were perhaps useful. And
yes, sir.
I would again just emphasize that the relationship, friendly relationship between the parties is a central issue here in terms of the hostility that's required. Page 6 of my brief, I cited the Wango case in which the hostility issue, true owner must have actual knowledge of the hostile claim, or the possession must be so open, visible, and notorious as to raise the presumption of notice to the world that the right of the true owner is invaded intentionally with the purpose to assert a claim. We didn't have any testimony, Mr. Holderman or Mrs. Holderman, that they at any point got to, in their relationship with respect to use of this, where they announced that they were now claiming this is a hostile right. This is different than a neighborly situation. This is more like a family situation. Can you have a family member living in your property with you for 25 years, file a claim for prescriptive easement to continue to stay in the property? I thought that the concept of unclean hands breaches that, which is why I briefed that. So I have nothing further at this time.
Okay. Thank you, Mr. Hanson. Mr. Zayas?
Yes, Your Honor, thank you. Again, Joseph Zayas on behalf of Mr. and Mrs. Holderman. And the first thing I think I want to point out is when counsel says that Mrs. Holderman testified about getting permission to go around the gate. That gate only went up 2 or 3 years ago. They have been using this road on a continuous basis for the last 40 years. And at the end of the 15-year period, that's when the right vests. So whatever happened after that gate went up is frankly irrelevant.
Well, I mean, it might not be dispositive, but it seems a bit much to say it's irrelevant, because if your clients had a claim, if she pulled up to a gate and said, open the gate so I can use this road, because it's, if it wasn't some asking permission, the asking permission is, if we have a trial, that would come in at the trial because it would be relevant, right?
Yeah, it would probably come in, but I would argue that it certainly, perhaps I misspoke, Your Honor, certainly wouldn't be dispositive of whether or not it was permissive use or not.
I agree, yes. Okay.
Frankly,
there's some evidence of it.
Maybe.
She's asking permission. Why is she asking permission if she doesn't need permission?
Well, frankly, I would argue, Your Honor, that that's more trying to keep the peace between the parties after they have kind of staked their claims and we filed a lawsuit trying to get this than anything else. I know the court certainly disapproves of self-help tactics. And once the gate went up, my client simply said, okay, we're going to exercise our rights under the court to try to get access to this road again.
Okay.
Now, my argument, Your Honor, is that
plaintiffs fire back. Cooperation isn't the same as permission. That's a bold counter. Basically saying, just because we work together doesn't mean we gave up our rights. But does that convince the judge? Jury's still out.
15-year period, their rights vest. So, it's not evident, or it's not evidence of permissive use within that first 15-year period, certainly. And I think that's important to point out. So the most important thing here is I think we need to realize that we must take the facts in the light most favorable to my clients. We're looking for questions of fact here. And I think when you take the evidence in the light most favorable to Mr. and Mrs. Holderman, we see that they've been using this path since they purchased the property in 1984. They both testified very clearly to that. Now, counsel has attached an affidavit from a prior owner saying, well, he put up a string, he put up a gate. He certainly didn't, confront my clients with that affidavit during their deposition. If anything, he's created a question of fact because my clients were very, very clear that they used that continuously since they bought the property in 1984 when they started to clear their property. So taking those facts in the light most favorable to Mr. and Mrs. Holderman, it establishes that they started to use that they continuously used that property. Now, if anything, what that affidavit does is show that use was hostile. It certainly shows that the prior owner didn't give any sort of permission for them to do so. Nothing within the affidavit suggests such a thing.
But even if you were right on that, that wouldn't establish the 15-year period is not established just through that.
No, I'm getting there.
So then, how do you overcome the whether you call it permissive use or it wasn't hostile, it's sort of two sides of the same coin, where here's this outlaw that by deed doesn't give your clients a right to use it, it gives these other folks a right to use it. And those other folks and your clients together are improving the roadway, the owners are buying the materials and your clients doing some grading. They're all kind of using that together. How does that ever establish or ripen into any kind of hostile use? It seems at least some, even were there no words of permission, which there are some words of permission in this record, even if there were none, wouldn't that be a pretty clearly implied permissive use?
No, Your Honor, and I'll tell you why. Because cooperation does not equal permission. And there's no case law that says specifically that if the parties cooperate, that it has to be a permissive use as a matter of law. Sure. I don't necessarily disagree with that, but as a matter of fact here, I mean, how is cooperative use inconsistent with the rights of the true owners or hostile to the rights of the true owners? Because the Holdermans, in using this continuously since 1984, were doing so as if they had a complete right to do it. And nothing that the defendants did changed the manner in which they were using this, which was under a claim of right going back to 1984. So simply because the defendants get there and see the Holdermans using this prior, because I think the record is clear that the Holdermans were there before, simply because they were there before, simply because they said, okay, so you're using it, we're using it. If you do this, I'll do that. Let's come to an agreement on how this is all going to be maintained so we can have this great, happy lake life. That in and of itself doesn't change the claim of right that my clients had previously established. No time did the defendants in this action say, at least according to my clients, I know there's testimony on the other side about this agreement that they reached, which is slightly different than what counsel represented. It wasn't, we'll buy the things, you do the maintenance. The agreement that the defendants tried to push was in exchange for letting you use the property, the lot, this is what we'll do, this is how we'll maintain it. Well, my clients denied that agreement ever took place. That being said, by the parties getting together and deciding how this is going to work, that doesn't interrupt their claim of right. In fact, it adds to it because it doesn't do anything. It accepts their use by that claim, and it doesn't do anything to stop that claim. It doesn't change the manner in which they were using it before.
So can I ask you then, and this,
Sure.
This ties in a little bit with Mr. Hansen's point, that an actual open, visible, notorious, hostile use can't exist only in the user's head, right? It has to be apparent to the world looking at the situation. Would you agree with that?
It has to be apparent, it doesn't have to be announced.
True, okay, but it has to raise the presumption of notice to the world.
Sure.
Right. So looking at this situation where they're doing this together, they reached an agreement about who buys the gravel.
Here's the crux. If outsiders looked at the situation, would they see the Holdermans acting like they own the road, or just friendly neighbors sharing it? That one perception could decide the entire case.
Who does something with the gravel? They're all really friendly. Give me one fact in this record that outside of your clients, inside their own heads, would have given presumptive notice to the world, let alone to these co-owners, to the true owners, that your clients were operating under a claim of right. One fact.
They were using it since 1984, long before they got here.
Any of them got there?
Yeah. Long before any of the other defendants got there. They were using this property. And instead of saying, no, this is ours, get off, you can't use it anymore, they simply continued to allow them to do it for several years before this agreement even took place. So maybe I would agree with the court, if it was a situation where maybe they all bought together, or my clients bought after them and said, hey, we want to use the road, we'll do this. But that wasn't the situation. For probably 5-6 years before any of these defendants purchased this property, my clients were regularly using that lot. And so when they get there and see my clients regularly using this lot, and in fact, Mr. Buckman testified that no, he didn't give them permission, he just kind of let it happen, which is eerily similar to the facts in the case I cited in my brief. The fact that happens raises that notice that the court is referring to. And the fact that they did nothing to stop that, other than try to figure out a way to maintain it, doesn't establish the permissive use the defendants are looking for.
What am I to make of your client's, Richard's statement during his deposition